Very good afternoon. Will the clerk please call the case?
This is Supreme Court case number CRA23-001, People of Guam Plaintiff Appellee v. Dennis C. Aldan, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Terry E. Timblin. Appearing for the Plaintiff Appellee is Attorney Marianne Wallachuk. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Attorney Timblin reserves 5 minutes.
You may proceed, Mr. Timblin.
Chief Justice, may it please the court. This case, at least for me, has been a rather long, strange trip going back to 2019. It has been a journey of trying to figure out what the government was attempting to or trying to accomplish with the amended indictment. The amended indictment has been slimmed down quite a bit by the elimination of the possession or use of a deadly weapon in the commission of felony charges and the terrorizing charges, and the court merging the two types of robbery, the place in fear charges and the display of what looks like a deadly weapon charges. So now the question is, how do we treat what is left? I used to prosecute back in the 80s, and if I had been handed the police reports in this case, and I was drafting an indictment, it would have read, Charge 1, every offense related to the Papa John's robbery. Charge 2, every offense related to the Loco Mart robbery. But that was apparently too easy, so we ended up with what this court characterized in its original opinion as multiplicitous charges.
But Mr. Timblin, isn't it an effect that that's what the trial court did when it actually sentenced the defendants, that it grouped them according to how you would have charged them had you been the prosecutor?
I'm sorry, that it...
You stated in your opening that had you been the prosecutor, you would have charged them according to the location and in reference to the various criminal violations. And I'm just pointing out to you that it appears that that's what the trial court did when it actually sentenced the defendant.
Well, that's not, again, what the indictment says. And again, I think it just invited confusion when you, again, charge the same thing basically twice. I always try to keep things simple. That is, here's robbery A, here's robbery B. It's just.
But I'm just trying to point out that the trial court seemed to have thought the same way as you are thinking, because it sentenced according to the location. It grouped the Papa John violations, the individual, the robbery on the individual to Mr. McDermott, the robbery on Papa John, the conspiracy to commit a robbery at the Papa John location, and same for Local Mart, and sentenced to 10 years each for each group of offenses, which is what you're saying, how you would have charged it.
Well, it would certainly be much clearer if it had been charge 1, Papa John's, charge 2, Local Mart. Maybe that's what she was intended, but again, I think it just, she said, well, no, I basically, if you look at each individual charge, the way the original judgment reads, she bundles them all in all three. That is Papa John's, Local Mart, conspiracy thereof, and then same thing, charge 2, same three things. I guess my basic point is that she decided that for these three things, he deserved 10 years. And that's the way it looked to me. And I think that's the way it could come across because of the confusion resulting from the indictment.
If you look at the indictment, the amended indictment, there was of course, count 1 and count 2 of the first charges, naming separate victims, McDermott in 1 and Regis in the other. And what we did was we vacated the second charge, right, on appeal. But the counts for both of the robberies, the convictions on charge one for each location remained, and each conspiracy charge, the corresponding conspiracy charge for those two counts remained after.
I think the
the man-
CJ meant the individual, the charges on the individuals.
Yeah,
Well, I guess I was getting to later, but we'll get to it right now. Again, that's a question, I guess, that I'm asking the court to decide. What did it intend when it vacated the second charge? But the charge that was left, charge one, count one, still included all three charges: robbery, conspiracy, and the court decided that was worth 10 years. Again, it's ultimately up to this court.
But what did the Supreme Court do? Maybe I'm a little confused as to what your understanding was contained in our mandate. What's your understanding of what the Supreme Court dismissed? Which charges did the Supreme Court dismissed when it reversed certain actions of the trial court?
What I believe that this court dismissed was, well, as I say, essentially, Mr. Aldan was charged with the same thing twice. He was convicted of the same thing twice and sentenced of the same thing twice. And
But what's the thing?
the
What is the thing? You said he was sentenced to the same thing and charged with the same thing. What is your understanding?
because each charge alleges the exact same thing: robbery, conspiracy. And
But you're not being clear in answering my question. I'm asking, what is your understanding? Was it as the dismissal of the robbery on the individual, Mr. McDermott, Mr. Regis, or was it the dismissal of the robbery of that's described by the location, the Papa John's pizza place, or the Local Mart location?
Yeah, I noticed the court addressed the issue of, okay, they charged him with robbing the business and they charged him with robbing the individuals. Or in this case, maybe they didn't rob the individuals, but they displayed a deadly weapon, what appeared to be a deadly weapon. And the way I read that one is that you said basically one robbery is it. It's all you get. Even though the business may have lost something, the owner or the employee was placed in fear, or there happened to be a deadly weapon displayed. And that's why I said before, it looks like you kind of scrunched that down too. That is, you can't make 2 or 3 robberies out of one robbery.
Maybe we describe it according to the actual statute. So didn't the Supreme Court dismiss the corresponding robberies that were in violation of 420A3, that where the victim was the Papa John pizza location and the Local Mart location? Wasn't that what the Supreme Court did in reference to the convictions that were dismissed?
Well, yeah, again, because as I say, you can't have a robbery or you can't turn a theft into robbery until either some human is threatened or harmed or threatened with harm, or the other side, of course, is, well, it happened is there was a what appeared to be a deadly weapon displayed. And
So the then that it dismissed that you referred to is the locations, the corresponding convictions that describe the victim as the location. In this case, it's Papa John's Pizza and the Local Mart market.
Well, it certainly came down to, I believe that all was left was a simple one robbery per establishment. Yes.
So then doesn't that mean that the remaining convictions that were not dismissed was the robbery of the individual, Mr. Regis, and the robbery of the individual, Mr. McDermott?
Well, correct. Again, the way I read it is you can commit robbery, second degree robbery, or third degree robbery, take your pick, several different ways. But if it's one incident where somebody walks in and says, give me your money, and walks out, I believe that's what the court did, which saying basically that's one robbery, even though maybe other people within the establishment lost something or were placed in fear.
But weren't the two victims in different locations? The McDermott, Teresa Jo McDermott, and Christopher Regis. They were two separate robberies. Both were named victims. They were under the A2 9 GCA 40.20A2. So if the charges for both those robberies under count one remain, because we vacated both of the counts under the second charge, where it was for local market, why did the trial court abuse its discretion when the minimum sentence for a second degree robbery is 5 years, the maximum is 10? And so what they did in this case was resentence him to 6 years for charge one, count one, involving McDermott, and charge one, count two, involving Regis.
I guess the problem I see with it is that well, she only went 6 and 6, which is better than 20, but could have been basically the same thing, 20 years all over again, 10 and 10. And which case the whole appeal, the previous appeal, becomes kind of a exercise in scholarly debate about how to treat this. But whether it's that or it's meant to correct a legal error, I guess that's my question to the court. And of course, the court can only answer that.
Well, the sentence was reduced from 20 years to 12 years, right?
I agree.
As a result of our determination that it was a multiplicitous charge.
Right, but when the court originally sentenced him, charge one, count one, decided he deserved 10 years. And that's what I think that, at the very least, is what the Superior Court was stuck with. And
It wasn't only charge one, count one. It was charge one, count one, charge two, count one, and the charge three, the conspiracy charge for the, in this case.
The way the judgment reads, basically, I think that was all rolled into one ball, basically bundled, shall we say. Robbery, conspiracies thereof. And when it's you decided that that's that, count one, charge one, count one is worth 10 years, and then the other 10 years goes out the window, then again, that's basically our argument. And as I said, my question can only be answered by your.
Didn't the trial court essentially sentence him to 10 years for the Papa John's robbery, or, involving that victim, then 10 years for the other victim, and then the 5 years for the terrorizing? So when we vacated the count two, or charge two, the second charge, counts 1 and 2, ultimately he got less of a sentence because he was given 10 years for one robbery and 10 years for the other robbery. And now the court gave 6 and 6.
Well, that's my point, is that it could have been in the same 20 all over again, and it wouldn't. Then, in other words, the whole appeal would have been just a kind of a dicta, I guess I'm going to call it, because she would, as I said, she bundled it once, and then it came back down, and one of the charges went, so she unbundled it, say, now we got this charge, this robbery and this robbery, and now we're gonna treat that as each one can be, get you 10 years. So I guess, I said, between the first appeal and then the resentencing, there had been nothing new, no new crimes committed by Mr. Aldan, no new negative information. And it comes down to it, when she did charge one, count one, it was worth 10 years. And together, all those together, and that should have been the max.
Well, when you look at the judgment, though, that was originally entered from the judgment of conviction from the guilty verdict, she sentenced on the first charge, second-degree robbery, the second charge, second-degree robbery, count one, and the other one was also count one, and then the third charge, the conspiracy, and that she gave 10 years. So she gave 10 years based on each respective robbery. So based on, the separate locations and the separate victims. And she did the same thing for the next one. For the first charge, second degree, count two, second charge, second degree, count two, and conspiracy, and she gave 10 years. So she split it up even in the initial sentencing. So when it came back down on remand, she basically did the same thing, but got rid of the second degree, the second charge, the second degree robbery, count one, and only sentenced on the first charge, second degree robbery, count one.
Well, the way I read the original judgment is that charge one, count one included both robbery and the conspiracy. And that's
not
all I
the
can say. That's
That-
where we part company, I guess.
Yeah, well, that's not how I read it. I'm looking at the judgment right now, and she puts as to the first charge, second degree robbery as a second degree felony, count one. Second charge, second degree robbery as a second degree felony, count one. So she took both the first charge and the second charge, count one of each one, which related to McDermott and to I think it was not Local Mart, but Papa John's, and then the conspiracy charge, and she sentenced the defendant to 10 years for that. And then on the first charge, second degree, count two, second charge, second degree, count two, and the third charge, conspiracy, she sentenced him to 10 years. So she didn't do it combining. I don't see anywhere in the judgment of conviction initially or on the later resentencing where she combined both robberies into one sentence.
Well, all I can say for sure is that in each charge, there included all three of them: robbery, conspiracy.
But that's not how she sentenced him. That's how the indictment read.
Yeah. Well, I just read it differently. That's all I can tell you.
Okay.
Well, again, my last contention, of course, is that if she's only entitled to sentence him on one of these, on one charge, bundled into charge one, count one, then the 6 and 6 could not be run concurrent. But I'll let it go at that. Thank you. Your questions have pretty much exhausted whatever else I was going to say, so I will leave it at that.
All right. Thank you, Mr. Timlin. Any further questions? All right, Ms. Wallace-Chuck.
Chief Justice, may it please the court. The defendant here is looking for resentencing based on bundling of charges. We don't think there was any bundling here, but if there was, as the Chief Justice noted, it's by the victim's location. So in the original judgment, you have charge one at Papa John's, and that's the robbery with the serious bodily injury. Then you have charge two, the armed robbery, and you have charge three, the conspiracy. And then you have the same thing for the Locomart location where the victim was. So you have robbery, serious bodily injury, robbery, armed robbery, and conspiracy. And then when there's the amended judgment after remand, it's again by the victim's location. So you have Papa John's, but you have charges 1 and 3. And then at Locomart, charges 1 and 3. And so that's how the court got 6 and 6. She could have had 10 and 10, but she looked at his I think special circumstances. I think he had some health problems and psychological problems. And so instead of making it 10, she made it 6 for each of the sets of convictions per location. And so instead of having 10 and 10, we've got 6 and 6. And of course, the others were dismissed, like the terrorizing, and the people dismissed the theft charges, you know, even before sentencing. So in this case, we would say that the sentence that was imposed was legal and permissible and correct. And therefore, we ask this court to affirm the judgment below. Thank you.
So,
Yes.
Mr. Timlin is arguing that all the charges related to local mart were dismissed by the Supreme Court, and that's where I think I understand him saying that you take the 10 years away and the only thing remaining is 10 years relating to charge 1. Why is that not correct?
I don't think that's what this court did. The court dismissed charge 2 because charge 2 named businesses as victims. And so it said that's not what the robbery statute is for. So charges 2 went away. So when you have this trio of convictions in the original judgment, in the amended judgment, it becomes a duo. So you just take out the charge 2, which is the armed robbery of the location instead of the victim. But the 2 separate locations, the 2 units of prosecution, the 2 different victims, the victim locations, those still remain. And so that's why we're arguing what we are. Thanks, Your Honor.
I have a question. Have you then abandoned your procedural argument?
Oh, about the motion?
Yes.
You know, I think the defense made a good point, but also this court could give guidance, for instance, because otherwise, what is the purpose of that statute if nobody ever has to make a motion and they can just argue it afterwards? So that was something that we were bringing up. Thanks, Your Honor.
But isn't that statutes couched in terms of it's discretionary for the defendant to file the motion prior? It says may. Why do you feel that the defendant is compelled upon remand that the defendant had to file the motion within 120 days when it said it may file?
I think the statute, Your Honor, says that the court may decide. I don't think it said the defendant may. So it's discretionary for the judge, but maybe it's something that the defendant should be doing. Okay, thank you, Your Honor.
All right. Mr. Timlin, you have anything on rebuttal?
I guess I should address the issue about brought up by the appellee's brief about filing a motion to correct a legal sentence. All I can say is if you go back looking at the record after the case came back down for on the mandate, I looked at it and I filed a what would you call it, a resentencing memorandum laying out pretty much what I've been saying today. And put it in writing, and plus there were 2 separate hearings on this resentencing. And I brought it up again the same way, about as clear as a bell. So if nothing else, the Superior Court knew clearly what our contentions were, and to to beat it to death and file something else, repeating myself, I see no point. I'll leave it at that.
All right. Thank you, Mr. Timblin. There being no further argument, the court will take the matter under advisement and will issue a written opinion. Thank you, councils. Court will now stand adjourned.